So your company is thinking about expanding into the Philippines. That's a huge opportunity. But you gotta know, this market has a legal rulebook that can either be your best friend or your worst enemy. Today, we're gonna break down the single most important rule you absolutely need to know before you make your move. Let's get right into it.
All right, let's start with a scenario, just to make this real. Imagine your company nails a huge project here, does amazing work, but then the local client just refuses to pay. We're talking $1 million. You want to take them to court. So can you? The answer, maybe unsatisfyingly, is it depends. And what it depends on is the single most important piece of paper for any foreign business in the country.
And this slide lays it out perfectly. It all comes down to one thing: a license to do business. Look at the left side. Without that license, you're in a really tough spot. You can't sue to get that $1 million back, but guess what? Anyone can sue you. Now look at the right. With a license, you're on a level playing field. You can enforce your contracts, and sure, you can be held accountable too. It is a complete game changer.
Now, this isn't just some friendly advice. It's a hard and fast rule from Section 150 of the Revised Corporation Code. It's really there to make sure foreign companies playing in this sandbox are accountable. Understanding this one rule literally dictates your company's ability to protect itself.
So how do you even know if this rule applies to you? I mean, what's the trigger? Well, it all boils down to a legal test defined by this one simple but incredibly powerful phrase: are you doing business? Because what feels like a simple sale to you, the law might see as full-blown operations.
So let's draw a really clear line in the sand here. On one side, you've got these one-off, isolated deals that don't need a license. But on the other, you have activities that the law says, yep, that's doing business, and that's what triggers the whole license requirement. Knowing which side of that line you're on is everything.
So what exactly does the law mean by doing business? At its heart, it implies a continuity of commercial dealings. That's the key word I want you to burn into your brain: continuity. We're talking ongoing operations, a sustained presence, not just a single, isolated event.
Okay, this is where it gets super practical. The Foreign Investments Act actually gives us this really handy checklist. So look, if you're actively soliciting orders, opening an office, or setting up local distributors, check. That is doing business. But a single one-time transaction, or maybe making a passive portfolio investment, just buying some stocks, or even having a nominee director on a board, the law says that is not doing business. See the difference?
And of course, court cases help us figure out all the gray areas. Take this one, with Avon Insurance. The big question was about reinsurance, and the court ruled that since the contracts were actually signed and finalized abroad, the company wasn't doing business here, even though the property they were insuring was in the Philippines. It just goes to show how nuanced this can all get.
All right, so let's say you've looked at the checklist, you've assessed your operations, and you've determined, yep, we're definitely going to be doing business. So what's next? Well, you need to get your official ticket to operate, the license to transact business from the SEC, the Securities and Exchange Commission.
The requirements can look a little intimidating at first, but let's just break them down. You're going to need your certified articles of incorporation and a formal application. Then you need something called a certificate of reciprocity. That's just proof that your home country lets Filipino companies operate there. We'll let you in if you let us in kind of deal. And finally, you have to appoint a resident agent for legal notices and declare your official place of business in the Philippines.
And you knew this was coming. There's one more crucial piece: the money. Within 60 days of getting that shiny new license, you have to deposit securities with an initial value of at least 500,000 pesos. You can think of it like a security deposit, really. It's just a good faith guarantee that there are assets in the country to cover any potential debts.
Okay, now for the fun part. Let's see how all these rules actually play out in the real world. I mean, legal theory is one thing, but courtroom battles over millions, that's where we see the real-life consequences of having or not having a license. Here's a worry that probably keeps a lot of executives up at night. What if you signed a bunch of contracts before you got your license? Are those deals totally worthless? Can you ever go to court to enforce them? Well, the home insurance case tackled this exact question head-on.
And the court's decision here is a huge sigh of relief for foreign companies. It ruled that contracts you made without a license are still valid. The law basically sees the inability to sue as just a temporary problem, a procedural hiccup. And here's the key: as long as you get your license before you actually file the lawsuit, you fix the problem. The defect is cured, and you can go ahead with your case.
But what about the other way around? Let's say you do the work, you deliver the service, but you don't have a license. Can your local client use that as a loophole to just not pay you for the services they already got? That was the big question in the Magna ReadyMix case.
So follow the story here. A foreign firm provides plant design and training. They do the work, and they do it well. But when it's time to get paid, the local company refuses. And their big excuse is, hey, you don't have a license. Seems pretty unfair, right? Well, the court thought so too, and it delivered a ruling that probably surprised a few people. The local firm had to pay up.
So why'd they have to pay? It all comes down to this really powerful legal idea called estoppel. In simple terms, it means you can't have your cake and eat it too. A company that willingly signs a contract and receives all the benefits from it is estopped, or legally blocked, from turning around and using a technicality to weasel out of paying. It's a critical safety net, and it's all about basic fairness.
So, you've got your license. You know you're protected by principles like estoppel. That's fantastic. But getting a license is just the starting line. Now you have to actually maintain it, because compliance isn't a one-time thing, it's an ongoing process. And here are the major pitfalls you need to avoid. You can actually lose your license for things like failing to file your reports, not keeping a resident agent, lying on your application, not paying your taxes, or, and this is a big one, operating outside the business purpose you originally said you would. It's really just about good corporate housekeeping.
So after navigating all these rules, all these definitions, and these dramatic court cases, what's the one big idea you should walk away with? What does all this really mean for your company's strategy here in the Philippines?
I think the best way to think about it is like this. Your license is your shield. It protects you from legal attacks and gives you legitimate status. But it's also your sword. It gives you the power to go to court, to enforce your contracts, to protect your investments, and to make sure you get paid. You can't have the protection without the power, and you can't have the power without the protection.
Which brings us to our final strategic question for you. Do you see the cost and effort of getting a license as just a barrier to entry, a headache to be avoided? Or do you see it as the price of security, the investment that gives you the confidence and the power to do business the right way? Ultimately, that's the calculation every global company has to make. Thanks for tuning in.